Okay. Good afternoon, everyone. My name is Jeremy Herman. I am an associate lawyer at Samfiru Tumarkin LLP in Toronto. So we do these live sessions multiple times a week across our offices in our provinces, in Toronto and Toronto, Ontario, and in Calgary, Alberta, and Vancouver, British Columbia. And the goal is to get your questions answered. And so that is my goal here today, to ensure that we can answer your employment law questions live, to make sure that you're educated on what your rights are. And so I hope to get many questions about that. Now, as I like to do, I like to start off all of these sessions with a hot topic that's going on. And so right now, it's very, very common that as the pandemic is coming to a close, some might say it's over, some might say it's still going on. But nevertheless, many employers are bringing their employees back to work, or they're asking that they do come back to work. And so we see this right now across all of the big banks, or many of the big banks. We see RBC is doing it. They're saying that you have to come back, I believe, 3 times a week. And we see different policies in this regard. Some employers are saying that you have to come back 3 times a week. Some employers are saying you have to come back to work, 5 times a week. Some are saying 50% of the time, but you get to choose. So we see all sorts of policies with respect to what is mandated for coming back to work. And again, there's various reasons why an employer might do this. They might want the employees to have better morale, camaraderie, a sense of camaraderie coming back, and coming back with the team and making sure that projects are done properly all together. But the question is, what is required by law, and does an employee who is working remotely throughout the pandemic, or perhaps even before the pandemic, have to go back to work when their employer requires them to do so? So for example, like I said, RBC is one of the banks doing this right now. So employees of RBC, do you have to go back to work 3 times a week as your employer is mandating? And so the question is, well, it depends. It depends on the circumstances of the employee. Every employee is different. There's no blanket rule about this. So what it depends on is whether the employee was working for the employer remotely throughout the pandemic only, or also even before the pandemic. And so what I like to look at when I get these kinds of consultations from employees is, when did you begin working remotely? Was it in 2018, 2019, perhaps even earlier? Or did it really start because of emergency measures related to the pandemic in March of 2020, or sometime after that? And if you started to work remotely prior to the pandemic, then you can say that that is a term of your employment, that you're able to work remotely. Whereas if you only started working remotely during the pandemic, then your employer has much more clout to say that you have to come back to work. And it would not be illegal to do so. However, if you've worked remotely prior to COVID, COVID was not a unique thing in terms of you being able to work remotely, then now if you're required to go back to work, you can say that that is a change to the terms of your employment, and you would be able to argue about a constructive dismissal. So you'd be able to say that your employment has been constructively dismissed, because even though my employer is not terminating me, they're not saying you're gone, you're fired. But what they are saying is that the terms of your employment are now changing. And if you don't agree to those changes, i.e. having to come back to work, then you can argue that that is a dismissal of your employment, and you would be owed full severance in that regard, which could be as much as 24 months of pay. So although we all have liked the flexibility of working remotely, it isn't necessarily illegal. And we're getting many questions about this now. And so it is not necessarily illegal for your employer to force you to come back. Now, as you see on the screen, it's a good time to talk about this tool. and it's called the Pocket Employment Lawyer. And you can find it at pocketemploymentlawyer.ca. And so what this is part of the Pocket Employment Lawyer is what we call our severance pay calculator. And the severance pay calculator essentially asks you very simple questions about your employment, how long you worked there, what you were earning, what your position was, what your age is. And then what the calculator does is spit out an amount of severance that you would be entitled to in your specific circumstances. And it's a great tool. It is very helpful for many people to get a sense of what their entitlements are, what their severance looks like. And then after you use that tool, we urge you to contact us, and you can reach us at help@employmentlawyer.ca. And then we can assist you with the process of obtaining the severance that you're owed. So we will leave it there. I'm getting many questions now, and so I'm going to respond to some of these questions. And then if there's other opportunities for me to bring up important topics that are happening in the employment law world, then I will bring those up at that time. So jumping into the questions, we see that Tristan says, my company has been recently sold to a new owner. It seems like I might be hired on, but I'm worried my previous years of service, almost 25 years, won't be acknowledged in terms of seniority. Great question, Tristan. So it really depends on whether your years of service get carried on. It depends on the type of sale that is happening. There's something called an asset sale, a share sale. We won't get into those nitty-gritty details. In many, many cases, it is a situation where you will be entitled to full severance if you're terminated after you join the new owner. And that severance will be determined based on your full seniority. So your years of service don't just get wiped away simply because your employer has sold their business. Okay. Now, again, it is a circumstantial issue. Every case is different. So I definitely urge you to contact us, and we can look at your particular circumstances and make sure that, yes, your seniority would get carried over. And we could even provide you advice as to whether this is something that we recommend that you accept to move on to work with this new employer that your previous employer has sold their business to. So Tristan, I hope that answers your question. If you have further questions, then just let me know. You can post it in the chat and I'll try to get to it. Okay, so now we have Cass on YouTube Live. And Cass says, I was promised a promotion verbally, but 3 months in, I'm taking on new duties, but my pay has not changed. I no longer want to take on more responsibilities for the same rate of pay. What can I do here? So this is, again, another very common situation. I think I had a meeting with a client about this earlier this week. And this is a good example of a constructive dismissal. So if you're being paid a certain rate of pay, and it's for you doing certain duties for your employer, and now suddenly, without you permitting it, your employer is requiring you to take on substantially more duties, then you can argue that that is a constructive dismissal of your employment. Again, it's not your employer saying we're terminating you. All they've done is add substantial more duties. But that very act of adding those duties could be construed as a termination of your employment. And Cass, you're absolutely able to proceed that way. And again, you'd be owed your full severance in that regard. Just on this topic, other good examples of constructive dismissal cases is even if your employment duties do not change, but let's say, Cass, in your situation, your employer said that your pay is going to be reduced. That, again, would be very clearly a constructive dismissal of your employment. Depends on how much it's being reduced, but certainly anything above 10%, it could be argued as a constructive dismissal, and you would be owed full severance then. Again, assuming that you do not accept the change. So if you accept these kinds of changes, if you say to your employer, sure, I'll take on these extra responsibilities, or sure, you can reduce my pay, then you permitted them to do it at that point. And then it would be very difficult for you to successfully argue that you have been constructively dismissed. So, Cass, I hope that answers your question. Again, if you have a follow-up question, or if anyone else has questions about this issue of having your duties changed or your pay changed, or you are being subject to working in a different work location than you've worked in than the one you've worked in for many years, that all of those things could be constructive dismissals. And I definitely urge you to ask your question now, so I can make sure I can answer them. Okay, moving on. So we have a question from Yvonne on YouTube Live. What if my employer terminated my position and 2 days later posted the same position under a different title? Good question. So what that sounds to be is actually legal. So it's a good, important topic to discuss right now. And that is the idea of a without cause termination. So an employer can terminate their employee with cause or without cause. Many cases, it is without cause, which means that your employer agrees that you're owed severance pay. You're owed your severance pay. But in that event, your employer is allowed to terminate you for any reason, so long as it isn't a discriminatory reason. So your employer wouldn't be able to say, Yvonne, we don't want you here anymore because of your gender, or because of your sexual orientation, or your race, or certain other factors that would be discrimination. But so long as that doesn't happen, your employer is allowed to terminate you whenever they want. They don't even have to provide a reason. They're allowed to post your job again for someone else to apply. But they do have to provide you with full severance. And again, severance is calculated based on factors, based on those factors. I said it earlier: the age of the employee at termination, the position, how much the employee was earning, how long they've worked for the employer, and generally the availability of similar employment opportunities in the job market at the time of termination. So all of these factors are considered, and your severance would be evaluated based on those factors. And again, check out our Pocket Employment Lawyer tool, because we will ask you all of these questions and we will provide you with an assessment of what severance you're looking at. So Yvonne, I hope that answers your question. Again, unfortunately, what it sounds to be is that your employer has done legally what they're allowed to do: terminate your employment so long as they pay you your severance. Okay, so moving on to the next question. My pleasure, Yvonne. The next question is from Christian on Facebook. And Christian says, my employer let me go because they say I'm not meeting deadlines quick enough. I've never had any complaints before. Did they have a right to do this? Another good question. Similar to what I was saying to Yvonne, your employer can terminate you for whatever reason they want. They can say you didn't meet deadlines, we don't like your performance, we don't like the color of your shoes. All of those reasons are valid to terminate your employment, so long as they pay you your severance. Now, what might make, Christian, your circumstances a little bit different is if your employer has decided that because you're not meeting the deadlines quickly enough, you're being terminated for cause, which is a different situation than what I was talking about before, which is a without cause termination. So if you're terminated with cause, what that means is your employer is saying you are not entitled to your severance, or we think you're not entitled to your severance because you weren't meeting your deadlines. In that example, although your employer might take that legal position that you're not entitled to severance because of that, they would most likely be very wrong. You would be entitled to your full severance, even if your employer has said that they have cause to terminate you because you are not meeting your deadlines. That would not, legally be speaking, be a sufficient reason to terminate you without your severance. Okay, Christian? So it's a good rule for everyone. If your employer terminates you for cause, absolutely still contact us, because in many, many of those cases, you are still owed your severance, and your employer is just trying to not pay you your severance. And so you should absolutely contact us. look us up at employmentlawyer.ca, as you see on the screen, and try to find we have tons of resources on this topic of without cause or with cause terminations. So you can learn more about it there, and we can arrange to speak with you directly about your issue. Okay, so let's move on to the next question on YouTube from Julian. So Julian says, I work weekly from 8 to 4, Monday to Friday. The past few weeks, I've been also working Saturdays, but I am not receiving any overtime pay. My site supervisor says, as we're in construction, this is not a thing for us. Is this true? It could be true. So what it sounds like your supervisor is trying to say is that if you work in construction, they are not obligated to follow what is called the Employment Standards Act, which is our minimum standards legislation in Ontario that sets out what your entitlements are, including to overtime, according to the laws of Ontario. Construction employees, if you work in the construction industry, that would be an industry that is not covered by the Employment Standards Act, but it doesn't necessarily mean that your employer is correct, Julian. So although they might say that you aren't entitled to things under our legislation because you work in construction, they may not be correct about that. So we get those kinds of issues frequently where employers will say certain things, but they're not legally accurate. So you may not actually be considered to be in the construction industry according to the law. It depends on what you're doing for your employer, what your duties are, etc. So I definitely recommend you contact us. It could be that you are owed your overtime. And so let us know. You can reach us at help@employmentlawyer.ca, and we'd be happy to connect with you directly. Okay, so at this time, I'm going to jump into another important topic, and the idea of paid sick leave. So for a while during the pandemic, the Ontario government permitted employees for reasons related to COVID-19 to have 3 paid sick days. So it would be, for example, if the employee had to take time off because they were sick, or they had to self-isolate, or they had to get a COVID vaccine or a COVID test, etc. All of those reasons are related to COVID-19, of course. And in those circumstances, the employee was entitled to 3 paid sick days. Right now, that is not the general law in Ontario. It was a temporary measure that was implemented to assist people during the pandemic. And so right now, what's happening is at the end of the month, at the end of March 2023, the government is stripping that back. And so we're going back to the default rules, which is that you are not entitled to 3 paid sick days. So that's a very important thing to note. However, it's important also to note that every employer might have a different policy about this. So even though the government may not require that an employee is entitled to 3 paid sick days for reasons related to COVID, it could be that the employer has a specific policy that they on their own decided to implement about how many paid sick days you're entitled to. Those are not uncommon. So your employer could have a policy that you're entitled to 5 paid sick days, or 10, or 12, or 3, however many per year. And if that is the case, then for you as an employee working for that employer, you would be still entitled to those paid sick days, even though this government reform is being pulled back. It's also important to note that you could be in a situation where you'd be entitled to unpaid leave as a result of being sick, or as a result of a medical diagnosis or a disability. In that event, as usual, you should obtain medical documentation for that to support your need for taking time off, and submit that documentation to your employer. And then they have a duty to accommodate you. They have a duty to allow you to take your sick time. And it could be for a week, it could be for multiple months. Every case is different, but that is another very important thing to note around this issue of sick leave and whether it's paid or unpaid. Okay, let's hop right back into questions here. So the next question comes from Danielle on Facebook. And Danielle says, I was recently let go after almost 4 years with the company in a marketing capacity. My contract stated a non-compete for 2 years. I have plans to start my own services and company soon, and this non-compete is going to make things extremely difficult. What are my options? So very good question. In many cases, and it depends on the timing of this non-compete clause, and it depends on the industry and exactly what work you were doing. But in many situations, non-compete clauses are not going to be enforceable anymore in Ontario. They were a very common provision that would come into an employment agreement. But the law has now changed, and they have said that generally speaking, non-compete clauses are not enforceable. And so, Danielle, it's very likely that you won't have issues, and your employer, although they might give you problems with this, they would be incorrect in doing so from a legal perspective, because it could very well be that the non-compete clause is not enforceable. But again, it depends on the work you're doing. It depends on the industry. It depends on when this non-compete clause came into effect. So I hope that answers your question. One other thing to note is a non-compete clause is different from a non-solicit clause, right? A non-solicit clause generally means that you're not taking away the employees or the clients or customers of your previous employer. Okay, it sounds like it overlaps with a non-compete, but they're actually different. And so that's something important to note, Danielle. Now, if you have a follow-up about your specific case, please post it in the chat and we can talk about it. Okay, so as I wait for more questions, I want to talk about another important topic that is still trending, and that's the idea of mass terminations. So as we're seeing in the tech industry, the cannabis industry, and many others, banking, there are many terminations going on. Some of them are layoffs, they're temporary, some of them are full-blown terminations. Very important to note that employees in that situation are entitled to their full severance pay. Many employers, for example, we've seen in the tech industry, are trying to provide what I've called one-size-fits-all severance packages, saying anyone who's terminated as part of this mass termination, you're all entitled to 3 months of pay, for example. And again, based on everything we've talked about today, that would be a problem and potentially illegal for your employer to say you're all entitled to the exact same amount of severance. The reason is because severance is totally circumstantial. It depends on each of the employees' situations. One employee for the same employer could have worked for 20 years and they could be 55 years old. Another employee could have worked for 3 years and they could be 25 years old. All of these factors will have a strong influence on what your severance will be. Again, your age, how long you've worked at the organization, and what generally the availability of similar employment opportunities in that industry. And we're seeing that a lot of terminations are happening in the tech industry. And so there's certainly an argument to make, and we make it all the time for our clients, that in the tech industry, it is hard to find a new job right now, right? And so even though they could be 30 years old in the prime of their career, well, it still could be more difficult based on the industry they work in to find a new comparable job, and that would impact the severance that such an employee is entitled to. So again, these mass terminations in these industries have been happening for months now, and they continue to go on. We have a long list of employers who are typically engaging in these mass terminations. Again, you can learn much more about this on our website at employmentlawyer.ca. and you can contact us again at helpanemploymentlawyer.ca if you have any specific question, if you're a part of these mass terminations, or if you're terminated in general, even if you don't think it's part of a mass termination situation. Okay, we have time for a little bit more, so let's dive into Farah's question on YouTube. So Farah says, I was recently demoted from a supervisor position. I was never given any negative performance reviews or discipline, so don't understand this. The new position is less hours and pay. Can they do this? No, they can't do that. So your employer cannot just demote you, pay you less, give you fewer hours. That would be a prime example of a constructive dismissal. Again, where the terms of your employment are substantially changing. So, Farah, let's try to put your case into context. Let's say you're earning $100,000 and your employer says, you know what, we don't think you've been performing well. Even if they didn't give you a performance review, they tell you you haven't been performing well. Therefore, we're demoting you. You're not a supervisor anymore. And now, instead of earning $100,000, you're going to be paid $80,000. That would be a constructive dismissal. Again, a situation where your employer is not saying outright, you are terminated, Farah. They're not saying that, but they are substantially changing the terms of your employment. They're changing how much you're paid. And if you don't agree to that, which you shouldn't, that would be a dismissal of your employment. You'd be able to leave your employment, contact us to help you, guide you through the situation, because it could be complex. But you'd be able to leave your employment and you'd be able to claim that you're entitled to your full severance pay, and we would help you get that full severance pay, which again, determined based on those factors. Check out our Pocket Employment Lawyer tool to determine what severance you might be entitled to given your particular situation. So Farah, that's a great example of a constructive dismissal. If anyone else is in these situations, reduced pay, reduced hours, you used to work where you have to travel 10 kilometers. Now your employer is saying, we're going to pay you the same, but you have to now travel 30 kilometers or 50 kilometers away to another one of our locations. I just had a case like that, a week ago, where the employer, or my client, wasn't getting a diminished pay, but their employer said, we're closing down one of our store locations. Now you have to travel to another location. You're going to have the same position, but you have to commute another hour. That would be a constructive dismissal, absolutely. And that employee was entitled to full severance. Okay, so we'll leave it there for today in terms of questions. You can ask more questions tomorrow at 1:30 p.m. My colleague Dan will be here to answer more employment law questions. I will be back again shortly, within a few weeks, and I'll be happy to answer more questions. And I appreciate all the questions I received today, and I hope it was helpful. So take care and have a good weekend.